Hey there, welcome back to yet another episode in this journey of demystifying the Patent Act. So, we have filed the patent application with appropriate forms while identifying the type of application, establishing the date of priority, and also ensuring that we have disclosed the invention so as to satisfy the requirement of Section 10.10.4. And of course, the application was filed at the appropriate office. Now, the application is with the patent office for them to take it forward to the next stage of prosecution. Publication is the next major milestone as far as India is concerned. An important one also, because no prosecution happens without publication of the application. In this video, we will talk about Section 11A that helps us to understand how, when, and what of publication. Section 11A starts with stating that no application will be published before a cooling off period is expired. Now, what is this cooling off period? The cooling off period is defined under Rule 24 as 18 months. 18 months from where? 18 months from the priority date. Now you see the first significance impact of the priority date. So no application will get published before the expiry of 18 months from the earliest priority date. But none of us like to get confined like this. I want to show off my inventions. I want to show off the competitors also. I want to show off the infringers also by saying that this is the application that is published, because you were not believing me when I showed you the receipt that I have filed an application. So if you want the application to be published, yes, you can definitely go ahead and ask or request the controller to publish the application by filing a request for an early publication. You use Form 9 and pay some extra bucks as per Rule 24A to get your application published. Moving on, 11A3. Every application is published either after the expiry of 18 months or at the receipt of the request for an early publication. It takes about 1 month for the patent office to prepare the publication after the expiry of the time period, after receiving the request from the applicant. But not all applications get published. There are few exceptions, as you might have noticed on the slide. So what are these exceptions? So one of these exceptions is when a controller has imposed secrecy direction over an application. When the controller is of the opinion that the invention contained in the specification may be relevant for security and defense purposes. In such cases, controller sends a request to the central government, Ministry of Defense, for their guidance with respect to what to do with the application. Unless a clarification is obtained from the central government, the publication is put on hold. In fact, no other process happens with the application. Another scenario in which the application may not get published is when the application is considered to be abandoned. Think of the section that we have already read, where you filed an application with a provisional specification. Either you forgot to file the regular application within 12 months or you decided not to file the regular application within 12 months. In such cases, it is assumed that you don't want to go ahead with the application and the application is considered to be abandoned. Can you recall that section number for me, please? 9.1 it is. There could be another case where the applicant doesn't want to go ahead with the application. In such cases, applicant can request for withdrawing the application. Yes, if you can file, you have an option of withdrawing the application also. But then such withdrawal request should be sent in good time frame, because the patent office requires some time for the groundwork for preparing for the publication. As per the Act, they say if you were to send such a request within 15 months from the priority date, then your application will not be published. But if such a request were to be received after 15 months, then the application may get published. Fair enough. So now the last two cases are either at the wish of the applicant or the mistake of the applicant. What about the first case? The poor fellow is still waiting for his application to be processed further. What happens? So in such cases, as soon as secrecy direction is revoked, when the central government is of the opinion that we are cool with it, we don't have any issues with the invention as such, then the application gets published at the earliest if the 18 months have already lapsed, which is the case all the time, or it will get published as soon as the 18 months are expired. So our application is published. Normal way early way, or through the secrecy provision delays. What happens at the time of publication? These days, because the databases are online, all the details are available for public to access. You can go over the application to understand what the invention belongs to and who it belongs to. Go to section 10.4. What about biological material? So at the time of publication, IDA also makes the biological material available to public. Great. So my application is published now. I can show off my invention to the world. I can show off the competitors. I can show off the infringers. But do I have some rights to stop these folks? Yes, you have rights as per section 11A(7). You have similar rights and privileges as if a patent was granted on the day of publication. But hang on, you can't go ahead and stop these folks. You don't have the right to sue anybody or initiate an infringement proceeding against any one of them. So what's the point of publication? But think of a time when your application is finally granted and you were able to successfully prove the infringement. In such cases, you can claim damages from the date of the publication. So this is the significance. Now it makes sense. So here is the gist of section 11A on how the publication happens through the normal route or how the publication happens through the early route. And what is the significance of publication where application details are published, biological material is made available, and you have rights and privileges as if the patent was granted on that day. Of course, you cannot sue anybody on that date. So when somebody were to ask you about the significance of publication, those 3 points are important pointers. So this brings us to the end of this video. In the next episode, we will visit the patent office to see how the patent office takes up our application for examination and how they go ahead with it. So I'll see you in the next video. Till then, be good and take care.